Good afternoon, everyone. Thank you for joining us for our second webinar in the Law and Economics Symposium series. My name is Crystal Pike, and I am a managing principal at Analysis Group, where I focus on healthcare issues, including matters involving the False Claims Act and the Anti-Kickback Statute. Right now, you are in muted participant mode, and we will be so your line is muted. To ask a question, please click on the Q&A feature and you can type your question in there. If you are experiencing any technical difficulties, you can also submit your concern via the chat function, and our technician will assist you. So questions should go into the Q&A. Technical difficulties should go into the chat. So just to get us started, it's been almost 20 years since the AstraZeneca TAP settlement was announced, where the government received, almost $900 million to resolve its investigation of allegedly inappropriate sampling that led to false claims being paid for by Medicaid and Medicare. And since that time, there have been thousands of investigations and qui tam cases brought against healthcare providers, with the majority focused on pharmaceutical and biotech products. Over the past 5 to 7 years, the focus of these cases has shifted from, what was more of a, off-label or allegedly improper marketing issues to those that have a lot of drug pricing concerns at their core. One example of that is, recent investigations into charitable donations to copay assistance foundations, and the government, has reached settlements totaling more than $1 billion for those types of cases since those investigations began. Over the next 45 minutes, we would like to discuss the recent trends in the False Claims Act cases, the link between these cases and drug pricing, and the economic issues that are often at the crux of these matters. I know many of you in the audience have substantial experience with these cases, and so we invite you to join the discussion via the submitting comments and questions in the Q&A. I'm delighted to welcome our distinguished panelists today. We are joined by Mr. Andrew O'Connor, who is co-leader of Ropes and Gray's Healthcare and Life Sciences Industry Group and is based in its Boston office. He represents clients in high-stakes government investigations and civil litigation, and has represented many well-known companies facing False Claims Act litigation. We are also joined by Mr. Jesse Siegel, who is Assistant General Counsel at Ipsen Biopharmaceuticals and supports businesses in each of Ipsen's therapeutic areas, including oncology, neuroscience, and rare diseases. He advises colleagues in a variety of functions, including advertising and promotion, incentive compensation, patient advocacy, patient support programs, corporate communications, and internal investigations. Next, we have Dr. Anupam Jena, or Bapu Jena. Bapu is a practicing internal medicine physician at Massachusetts General Hospital and also a professor of healthcare policy at Harvard Medical School. And he will provide insight from the dual position of both a physician and an economist. And last, we have Chris Odie, my colleague at Analysis Group. Chris was previously faculty at Kellogg School of Management at Northwestern, where he conducted studies on many healthcare issues, but one of them among it being the link between drug prices and patient cost burden and drug utilization. So with that as introduction, I'd like to kick us off by asking Jesse, what are some of the key compliance priorities that are facing pharma biotech with respect to the False Claims Act and anti-kickback issues?
Thanks, Crystal, and thanks to Analysis Group and for having me. This probably won't surprise anyone. While I am a very happy, content employee of Ipsen Biopharmaceuticals, the opinions and thoughts that I express here on this webinar are mine and not necessarily those of my employer. In terms of key compliance priorities, things that I'm thinking about when it comes to the Anti-Kickback Statute and the False Claims Act, I think quite a bit about patient support generally. I think most of us here, panelists and audience members, are aware that there has been that enforcement trend away from what I think of as traditional off-label cases, given the First Amendment cases that make those cases a little bit hard to win for the government, and a trend toward cases targeting fraud and abuse, where the First Amendment either isn't a factor or is much less of a factor. And so when I think about the anti-kickback statute, we all know that there are no safe harbors for traditional patient support like copay, temporary patient assistance, reimbursement, education, what I think of as like the nuts and bolts of a traditional patient support program. And so I think the government understands those traditional aspects of a patient support, but I don't think the government has as strong of an understanding of the high touch patient support that's often required in rare or ultra rare diseases. And so when it comes to things outside of those nuts and bolts, I do worry a lot and think a lot about how to structure those in a way that shows our compliant intent to support patients, rather than using those as some sort of inducement to refer, prescribe, purchase, et cetera. In addition, when you introduce products that may be buy and bill into the mix, that obviously changes things a little bit, because in addition to what I just described, you're also thinking about things like avoiding the misimpression that you're marketing the spread, for example, telling someone how much they could make by prescribing a product, which is obviously another, third rail, so to speak, when it comes to enforcement. So I spend a lot of time thinking about patient support. There are other things too, but when you say the key compliance priorities, key things that I'm thinking about, that's really where I'm spending a lot of my time.
Thank you. And Andrew, over the past few years, what changes have you seen in the types of matters that are being either investigated or brought by whistleblowers in the False Claims Act and anti-kickback space?
In many ways, what's old is new again. We're seeing a resurgence of some of the more traditional kickback theories we were familiar with from 10 plus years ago. We're seeing a lot of attention paid to speaking programs and consulting arrangements, even royalty payments, which really haven't been the subject of too much scrutiny since hip and knee back in 2007. We are seeing attention being paid to the high prices of medical products, be they pharmaceuticals or devices, but we're seeing DOJ come at that issue from a variety of different angles, and using the anti-kickback statute as one tool to go after company practices that they see as supporting artificially high prices. And particularly with things like the new guidance from OIG on speaker programs and the more austere restrictions that they suggest companies should be placing on those sorts of engagements, DOJ seems to be taking a closer look at the kinds of arrangements with physicians that maybe even 5 or 10 years ago wouldn't have raised any eyebrows. So we are seeing a lot more attention paid to some of these meat and potato type kickback cases that were not necessarily making headlines for the last 5 or so years. Copay cases, the kind that keep Jesse up at night, have, I think, fallen out of the headlines a little bit because they're old news, and people have sort of heard about it and now to see it as one of many risks. But the reality is DOJ is continuing to pursue those cases, and we have seen even in cases that are focused on some of the other kickback theories, like I just mentioned, there are offices now, U.S. attorneys' offices, that as a matter of practice seem to be including subpoena requests around copay issues in their subpoenas that seem focused on some of the other theories we're talking about. So even though I think there's some perception that the copay assistance wave may have crested at this point, it is still a very active area for DOJ and a very significant risk area for clients in this space. Finally, one other trend we've seen, and this is something that DOJ itself has said publicly they're going to be focused on, is managed care, specifically Medicare Part C, Medicare Advantage. This is for the last couple of years made the department's top enforcement priorities with respect to the False Claims Act. And we have seen them follow through on that. They're very interested in the types of arrangements that Medicare Part C plans have to obtain patients in the first instance, steering of patients toward specific plans, payment arrangements in the marketplace for people to recruit patients to certain plans. But we're also seeing, especially in light of OIG's recent report on the quality of care received by Medicare Advantage patients, increased scrutiny of the level of care that is provided to patients when you see both the insurance carriers and in many cases the providers being paid a capitated rate, so that they're being paid a flat fee for each patient under their care without regard on the back end to how much care they actually received. And there's certain risk factors on the front end that can be weighted in, and DOJ is very interested, number one, in how those risk factors on the front are being calculated, and number two, given OIG's recent concerns about patients being undertreated, we're seeing DOJ focus on whether or not the providers who are being paid this flat rate are skimping on the care provided to patients. And the economists in the panel can probably parse the nuances of the economic arrangements better than I can, but it's not hard to imagine what DOJ prosecutors are thinking is going on when you see providers that have certain patients who are very high cost, and the cost of the care that they're actually receiving far exceeds what the providers being paid under some of these Medicare Advantage arrangements. And I think DOJ and OIG are going to continue to be focused on whether those sort of high cost patients are being provided with all the care that they're entitled to.
Great. And we have one question from the audience about how patient support and copay investigations specifically relate to the False Claims Act, and is it just the False Claims Act, or is it an anti-kickback concern, and what is the link the government is making there?
Sure. So these issues are almost always dealt with in tandem. The anti-kickback statute is a criminal statute. And there are criminal penalties associated with it, but it is also a predicate to False Claims Act liability, because the statute itself actually says if a claim is submitted to Medicare or another federal program as a result of a kickback, it's automatically a false claim. So DOJ would take the position that anything that's billed to the government that is in some way tainted or results from a kickback is also a False Claims Act violation that gives rise to civil liability and treble damages.
Great, thank you. So turning, to the economic side of this a little bit more concretely, Chris, as Andrew mentioned, the investigation around these charitable donations to organizations who support Medicare patients with their out-of-pocket burdens, continues to be a focus and a priority. In your prior academic work, you studied the issue of how cost sharing impacts the use of specific drugs, and have worked with many of the experts that often appear on the government side of these matters. Can you summarize for us what the economic concern is that has led health economists to study the issue of subsidizing cost sharing?
Definitely. As an initial matter, the purpose of out-of-pocket costs is to disincentivize patients from using low-value medical services, which means medical services for which the benefits don't justify the price tag. Evidence that higher out-of-pocket costs, so lower utilization, goes back over 30 years. In recent years, my co-authors and I have documented that drug manufacturer coupons increased utilization of branded drugs for which a lower cost generic equivalent was available. The additional spending on these drugs was likely lower value because the patient could have received the same benefit from the lower cost generic equivalent. Because copay coupons are not allowed for Medicare, that study's findings were limited to a commercially insured population. The same concerns that lower out-of-pocket costs can increase the use of low-value spending is at least theoretically relevant more broadly. The concern is at least theoretically relevant to reductions in out-of-pocket costs from copay grants by third-party patient assistance charities that predominantly provide grants to Medicare patients. It's also at least theoretically relevant to drugs that do not have generic equivalents, because insurers generally have an incentive to set higher cost sharing for lower value drugs. All that said, I'm unaware of any estimates of the effect of independent patient assistance programs in particular on drug utilization.
Chris, well, maybe I could just chime in, but before I do that, actually, Andrew, I like your phrase, what's old is new again. That's my own philosophy and my own aging, so I got to keep that in the back of my mind. So Chris, let me just pick up on something you said I think is really important here, which is that the impact of copay grants through charitable foundations hasn't really been studied empirically, and we wouldn't necessarily expect that what we see with drug coupons is going to have the same effect for different products in a completely different type of setting. I think that's important because as researchers, we have this tendency to try to generalize one finding to the entire world. And that's great for writing scientific papers, but it's not great when there's nuances that you have to consider when you're working on cases like this. The other thing is that copay charities, they typically have disease funds that cover a lot of different treatments for a given disease. And often these are sort of the first in class or better treatments. So when a company donates to a fund that in which the fund covers a lot of different drugs, the company may not necessarily know or even be in control of what drugs or products the charitable foundation is going to disperse funds to or is going to cover. So I think that's a fundamental difference between the type of work that you and others have done, where we're looking at coupons and if they can potentially drive patients to use branded products versus bioequivalent generics, versus this very different question of charitable assistance foundations, which has gotten more attention recently. It tends to cover much more kind of differentiated products. And the last thing is there's also this question of whether or not, and this I think is actually for me as a clinician, it's really the first order question I've been thinking about is, what is the effect of these foundations and grants on patient health, and secondarily on cost of payers? Could be Medicare, could be commercial insurers, because in a lot of these cases, and Jesse alluded to this, the burden of disease is enormous. It's especially true for people who have serious illnesses. It's especially true for people who have rare diseases that are also serious. And so from an economic perspective, and certainly from a clinical perspective, I don't see how we can have these discussions without weighing in on the health impacts of the treatments.
And Andrew, I'm curious, on that point with the broader question of patient benefit and kind of overall costs outside of just the specific drug that is at issue. How does the government or the case law sort of view the relevance of that bigger picture question?
Well, from a policy perspective, you would certainly hope that the patient impact is front and center, and that the benefit that's being provided by a lot of these products would be top of mind. And it certainly is a big part of the discussions that we would have with the Department of Justice, maybe less so with Relators Council. But the way those sorts of issues interplay with the case law is a little bit complicated. The anti-kickback statute has been interpreted, at least by DOJ and some courts, to mean that if even one purpose of the payment you're making or the arrangement that you have is to generate referrals or generate business, DOJ would say that's a violation of the anti-kickback statute as long as the other elements are met, and it doesn't fit neatly into one of their very specific safe harbors. So when you're looking at a kickback allegation through that lens, where one simple purpose can, in DOJ's view, taint the whole arrangement, even if it's very valuable or important to patients, that opens up a lot of possibilities for some pretty inefficient results. Now, the Office of Inspector General at HHS, through its advisory opinion process, will often analyze particular arrangements and whether they would take the position that enforcement would be warranted against the individual or the company that submits this advisory opinion if they implement a particular arrangement. And that's called a facts and circumstances analysis in many cases, because they'll conclude that maybe on its face it could violate the AKS, but OIG in the exercise of its discretion wouldn't take the case forward. And in that analysis, OIG does consider the patient impact, and that is one of the factors, but it's just one of the factors. And as many of the folks on this call probably appreciate, OIG's advisory opinions are certainly important, and sometimes they're the only guidance out there, but they can be of somewhat limited utility to the extent you have a whistleblower, for example, bringing a qui tam case, and you're dealing with an advisory opinion that's maybe analogous but not yours, and it doesn't fit neatly into a legal defense. So oftentimes when you're talking about patient benefits, you're living in a world of discretion and asking the DOJ or the OIG to consider these collateral consequences. When I think one of the fundamental problems is the statute itself doesn't expressly take account of some of these very important policy considerations, like the impact on patients, the positive impact of some of these arrangements that have been challenged historically under the anti-kickback statute.
And is the same true when you're talking about like the case law on what is relevant for damages in these cases? I mean, that I hear you on the liabilities side and whether or not it's considered a kickback or not, but on damages, is the broader question of overall cost or benefits to the patient, how have the courts viewed that?
Yeah, so of course, under the False Claims Act, if you have the government or a whistleblower saying there was an anti-kickback violation that led to a false claim, at some point you have to ask, well, how was the government harmed? Because that it will determine in part the amount of damages under the False Claims Act. And in many cases, we find ourselves taking the position, and I think rightly so, that the government wasn't harmed at all because of whatever treatment was at issue. And in those cases, we would argue the damages is zero. But that is a fight that has played out in the courts, and there's some mixed law on that. DOJ, for the record, would certainly not agree with my position. They oftentimes come at these things by saying if there's even a whiff of a kickback that's tainted this whole thing, the government's owed every cent back, regardless of what the benefit is to patients. But you're absolutely right that this is one area in talking about damages that we are often fighting over the benefit to patients and asking the government to account in terms of dollars for the benefit that was actually received, despite whatever legal violation they've alleged.
And Jesse, I'm curious your thoughts on this from the perspective of having to advise your business teams on how to make decisions about support programs or whether it be like consulting programs or anything like that. How do you weigh in the patient benefit versus the risk here?
Yeah, I almost always think about it by reference to the so-called prudential factors of the anti-kickback statute, and in particular the one about over or inappropriate utilization. It also gets to something that Chris was talking about a moment ago, right? Like, if it's not whether a product is it used inappropriately, or is it used too much? Is there, like Chris said, a true lower cost alternative? And I usually think about it in that framework. And so it kind of gets back to what Andrew was saying, with these advisory opinions, we usually just use those to read the tea leaves, at least from the government's perspective. Even if, how close are you to the advisory opinion? How narrowly do you think OIG would interpret it? And so when I think about it, when I advise my internal clients, I'm usually thinking about, okay, well, how does it fit within that framework? Is there an advisory opinion that we can cling to, even if, as Andrew pointed out, it doesn't stop a private a qui tam, a relator from bringing a case? I usually think about it as within the context of that particular prudential factor, and then use the advisory opinions to as sort of like lodestars.
And I think that the question of overutilization or appropriate utilization sort of, is starting, it's related to the issue of causation, right? Which is something that, is always a central issue in the off-label False Claims Act cases. And so I'm curious, Bapu and Chris, like from an economic perspective, how do you assess causation when the issue is more of like a cost sharing or price related issue? And so could you speak about like causation from that perspective?
Sure. So in the matter of promotional messages is a basic matter. The issue is that many purchases that would have still occurred but for any promotional activity. So for the promoted products tend to be very different from products that are not promoted, and promotions often occur at the same time as other events that would affect utilization. The same is true for copay assistance or for price concession matters. In my academic research on copay coupons, we were able to get around this by using effectively a natural experiment. There are bans on copay coupons. But absent that kind of a natural experiment, it's really difficult to credibly tease out any kind of a causal effect from any of these kinds of arrangements.
Crystal, let me also just say that I mean, I don't think you could study this question credibly and try to assess an issue of causation, what's causing a physician to prescribe a drug or causing a patient to fill a prescription for a drug, without sort of having an understanding and incorporate all the different factors that go into why a doctor may prescribe one drug for another. I mean, I certainly consider it. I think all doctors consider a range of different factors. And like obviously, or maybe not so obviously, the most important one is going to be a patient's medical condition and need. It seems obvious, but sometimes that's not at the forefront of discussions about what drives or what drove a prescription to occur. But obviously, that's the most important thing. And it is the case that some drugs work better for some patients, and that's a critical factor that I think any doctor and certainly patients would be considering and be mindful of. But there's also factors like a doctor's experience, what the clinical evidence is, what the guidelines say, and all of those things are important. And these are the kinds of factors that are important when you're thinking about the economic question of causation, because if the prescription would have been written anyway, if it had occurred anyway, as a result of any of those factors or any other driving factors, then from an economic perspective, you can't really say that there's damage that stems from the alleged misconduct. And so all that is to say is you have to consider these other factors when doing a causation analysis. And
when you've seen experts on on the government side or on the relator side, would you say that the issue with, like, how are they approaching causation, if at all, and what would you say the issues are with those?
Yeah, I mean, say not to pick on economists on either side of the ledger here, but it's often the case that I've seen experts opining on issues of causation without using sort of established frameworks of causation, thinking about what are the various factors that lead an outcome to occur. Could be a prescription to be written, could be a prescription to be filled by a patient, but without really considering all the different factors. And it surprises me in some respect, but that is the way that we should be thinking about these issues from an economic perspective.
And Andrew and Jesse, I'm curious your thoughts on causation. Andrew, you've mentioned a few times sometimes there's just this taint theory and it feels like the causation, isn't as front and center, but I'm curious your thoughts on causation in the pricing context that, from the court or legal perspective.
Yeah, I mean, it is one of the hotly disputed areas. And there was the good question earlier about how the anti-kickback statute relates to the False Claims Act, and the statute was actually amended to clarify that any prescription that, quote, results from a kickback is tainted. But there still has been this ongoing battle about what it means to even result from a kickback. And there was actually a very interesting case out of the Eighth Circuit recently that said, well, results from means the kickback had to be a but-for cause. So I think that was very helpful in clarifying what we're talking about when we think about causation in this context. The government has to prove that the doctor would not have written the prescription but for the misconduct, whatever that might be, whether that was a consulting payment, whether that was a copay coupon, whether that was some other arrangement that the government is challenging. So I do think that's a helpful development. It's one case in one circuit, but I think it gets at this key issue of the need to compare the but-for world with what actually happened and only holding people liable for the delta.
And how do you think the government or other plaintiffs will try to distinguish some of the current FCA cases from that recent Eighth Circuit one?
Well, for one, I think there'll continue to be a factual disputes about what the but-for world would have looked like. To Bob's point, I think the quality of analysis we see varies widely, but it is generally the plaintiff's position that, of course, the physician would never have prescribed this drug if they hadn't gotten paid $1,000 to speak about it. So I think they'll continue to challenge that factually, and I think they'll continue to challenge the legal principle that the Eighth Circuit laid out, and that could be another area where we see a circuit law develop independently over time, as we have in many other areas of the False Claims Act.
Okay, great. Jesse, I want to go back to something that you and Andrew touched on. In many of the government investigations, particularly surrounding copay issues, there's this belief that the donations to charities or other forms of patient assistance allow the manufacturer to charge higher prices. Can you say a little bit about, from your perspective of actually, working inside of company that is setting prices for drugs, what are your thoughts on this belief in this link?
Yeah, I mean, I certainly don't want to belittle or minimize what Chris is saying. I think to say it's his belief, as he's pointed out, he's done academic research on this. He didn't wake up one day and decide that, people work to test this sort of hypothesis. So, but I guess for me, I think it's so dependent on the type of product and the disease state. So I can understand perhaps a little bit better where there are true, Chris used the term lower cost alternatives, in a world where there are true generics or true bioequivalents. I think it's a little bit easier for me to understand it intuitively. I do struggle more in the specialty space where there really isn't a true alternative. While I'm not an economist or social scientist of any kind, it strikes me that there are too many variables here. Like, it's one thing if there's a generic or a true bioequivalent, but if there isn't, you've got not only copay here and not copay there, but you also have a situation where the products aren't the same. And so how do you really analyze this in a way that kind of makes intuitive sense? I think for me, particularly where you're talking about, in certain cases, rare or ultra rare indications, where the economics are such that the prices have to be set at a certain level, or it just doesn't make sense for companies to innovate in that space. Is it the copay really? You have products like Zolgensma, for example. That's an extreme, but without copay, okay, maybe prices would get a little lower, but would they get low enough to the point where it would even approach affordability for an actual patient? And I guess I worry that the prices wouldn't get low enough to actually make it affordable. And if prices did get low enough to make it affordable, it would no longer make economic sense for innovation. And I know that this is I'm not saying anything that anyone on this call hasn't heard a million times before, e.g. in connection with the Inflation Reduction Act arguments. But I really am, I struggle to get my mind around that. And the problem with it, this sort of empirical question is, in order to truly test it, I guess whose burden is it to set up that experiment, and what are the consequences of that experiment in terms of patient care, patient health, patient life? Those are just some of the things that pop into my mind.
Chris and Bapu, do you have anything that, like, what are your thoughts on the link between patient assistance and drug pricing?
So as Jesse says, right, we're not going to have something like a randomized control trial to try to get at this, both for ethical reasons and because we only have one world in some sense to be doing all of this in. But so I want to take a step back and sort of start with what the theoretical concern is here. The theoretical concern is that insurers use formulary placement as a carrot to drug manufacturers. And so in exchange for favorable formulary placement, an insurer wants a good price. Patient assistance could potentially make favorable formulary placement less important for a drug manufacturer because it allows the drug manufacturer to pay the patient high cost sharing. This in turn makes the carrots that insurers had to negotiate lower prices less important, which in turn can create upward pricing pressure. There is a substantial economic literature which shows that selective contracting by insurers lowers prices. That said, there are no empirical studies that I'm aware of that look specifically at these third-party patient assistance programs. I'm aware of one study that looks at the effect of copay coupons on negotiated prices. That study is, I would say, heavy on economic modeling, kind of by necessity. The study finds that copay coupons increase prices by about 8%, right? So like if we think about that in the context of something like a $10,000 drug, we're talking about $10,000 versus $9,200, right? So I think that to Jesse's point, right, like we're not talking about a $10,000 drug being like $50 absent these programs, right? It's real money, but the difference in price is real money, but the price tag is real money too.
Bapu, do you have any thoughts here?
Yeah, maybe I can follow up on that. And it sort of echoes an earlier point that I made about generalizability and how we use the evidence in the literature to inform our thinking in these sorts of cases. Many of the times the reports that I look at, they're filled with studies in the literature, and the studies are used to make certain points. And that's true for experts, both the plaintiff side and defense side. And I would say that we have to be cautious when we use the existing literature to inform a question for which the specifics of the drug, the disease setting, the allegations, the outcomes are just so different from what we observe and what we could plausibly rely upon other studies to tell us. So I think that, and let me just give a clinical example, for example, we know that for patients who have atrial fibrillation, which is a rhythm disturbance of the heart, that they're at higher risk for stroke. And we know this from a lot of data, and we know that blood thinners in these patients can reduce the likelihood that they have a stroke, and that's been studied in many randomized controlled trials. So if you have a patient who has atrial fibrillation and certain risk factors, you would, as a physician, probably want to put them on a blood thinner to reduce their likelihood of stroke. Now, if I'm in the hospital and a patient comes to the emergency room and they have atrial fibrillation and they've just had a stroke, and I look at the medical record and they're on a blood thinner, I'm not going to look at that patient and say, oh, you couldn't have had a stroke because you're on a blood thinner. That wouldn't make any sense, right? I mean, you have to look at the actual facts, to use the terms that we use here, the actual evidence in front of you, and make a conclusion about whether or not the blood thinner was effective in that person or not. So that's sort of like the way I think about these issues, is that this applies to the issue around pricing. What might be true in theory may not be true in practice, and what might be true in practice in one setting may certainly not be true in different settings. And so I think we for those people who are academics and try to rely on the academic literature to inform their opinions, I think we have to have a little bit of hubris and be careful about the extrapolations we make from studies to the particular questions that we're dealing with in a litigation context.
Bapu, give Chris a break.
By the way, there are many good studies and many bad studies, Chris. All studies is good, all good.
Andrew, do you have anything you want to add on the point with drug pricing in the link?
Yeah, only that I think we are going to continue to see these differing viewpoints play out. Even if DOJ ultimately feels like it's gone after the arrangements that in its view distorted decision making the most, there's still going to be whistleblowers who bring these kinds of things forward, and the sorts of questions that Jesse and Bapu are raising are going to continue to be fought over, I'm sure.
Okay, we have one question from the audience for Bapu, and from the physician perspective, can you say a little bit more about physician prescribing decisions and whether the False Claims Act or Anti-Kickback statute play directly into those?
Is this white coat inducing questions that otherwise would not have occurred? I would say, my general thought is the following: that the most important determinant is the clinical factors that are involved. What disease does a patient have? What medications does a doctor think is going to work best for them? What side effects or interactions might that medication have with other drugs they're on? Like, that's got to be upwards of 80 to 90% of what drives prescriptions. Now, could there be other things that are involved as well? Doctor's experience, potentially other factors? Absolutely. But if I'm engaged in a discussion with someone who says that 100% of a doctor's prescribing decisions was caused by any single factor, and that single factor, by the way, is not whether or not the person had a clinical need for that drug, that can't be a meaningful discussion, because something is clearly missing.
So, we're right about at 12:45, and so I just want to pause for a moment and see if there are any other, if there are other questions from the audience, please, put them into the Q&A now. But also, Andrew, I'm just curious your thoughts on, going back to your starting thing of what's old is new. Probably if we had one of these discussions back 10 years ago and said, in 10 years, where do you think you'd be? We wouldn't necessarily think we would be, circling back to the same issue. So, what's your thoughts on where this is going to go, down the road? And in 3-4 years, is this still going to be the same? Or do you think something like the, some of the things that have been addressed in the Inflation Reduction Act will change things? Like, what are your thoughts on the future?
Well, the little I know about the academic literature on predicting the future is that experts are really bad at it. So with that caveat, I would say that these trends, they seem to be cyclical and or at least temporary, because I think DOJ and the relators bar on any given issue are going to go after the low-hanging fruit first, right? They're going to look for the cases that are easy to bring in their view. And the industry will learn from those cases and refine certain practices that might make them easy targets on whatever the theory du jour is. So I think that's one reason we do see ebbs and flows in some of these theories, because the industry does respond and take steps based on what it's seeing, getting its fellow industry members in trouble, for better or for worse. That can have an impact on behavior across the board. As far as what we'll see going forward, DOJ has announced a number of priorities in this space. We talk about Medicare Advantage. I think that's going to continue to be on the radar. Opioids will continue to be on the radar. I think we'll also see increased scrutiny around the cybersecurity issues and things like that, which don't necessarily play into what we're talking about today, but it's what we hear DOJ saying they're interested in, which is about the best evidence we have to go on. But right now, it does seem like these cases, which, as I think folks appreciate, go on for many years, are continuing to focus on these very basic kickback issues, and I think with the OIG guidance on speaker programs, they may have breathed new life into that theory, and then we'll probably be looking at cases along these lines playing out over the next several years.
Okay, great. Well, we don't have any other questions, so I will take this chance to first thank all of you for being here today, and thanks to our panelists for sharing your thoughts and being candid with us over the past 45 minutes. I just want to mention that our third webinar in our series will be held on October 12th. Invitations will be going out for that soon. And the topic will be data mining and the False Claims Act key takeaways. So similar, staying on the False Claims Act trend, but turning a little bit more to how data is being used and mined in that context. So please, we hope to see you all there, and mark your calendars. And thanks again, everyone.